I'm going to cede the podium to Kathleen now to lay out the law for us, and then I'll introduce the panel while they're assembling after Kathleen's presentation. Okay.
Thank you, Mary Lou. Thank you. Is this on? Oh, okay. I'm going to try to just give you not Employment Law 101, because that would probably take a week, but give you just enough basics so that it might help you in your analysis of the hypo that we're going to talk about this afternoon. So I've been asked to talk about the rights of employees to engage in speech and political action and the right of employers to forbid such speech. 86% of the workforce and 75% of lawyers are employed by private employers. Thus, they do not have First Amendment rights. Those are reserved, such as they are, to public employees who comprise the rest of the workforce. But the speech of employees in the private sector might still enjoy protection by virtue of contract, statute, or common law. Preliminarily, I'll note a bit of an anomaly. While employees don't have First Amendment rights, employers themselves, in some limited circumstances, might, because no one, including private employers, may constitutionally be compelled to speak. This occurs when an employee's speech is the equivalent of the employer's speech, an employee so identified with the employer that their speech is attributed to the employer. In that case, the First Amendment might constrain a court from compelling retention of that employee. In the law firm context, and perhaps others, this could be regarded as speech. In the law firm, the leadership of a law firm, and perhaps others, could be regarded as engaging in the speech of the firm itself. In the 19th century, the natural state for most employees was naked. No protection at all from the power of the employer to fire for any reason or no reason. This is called, as I'm sure you know, the at-will doctrine. Over the last century and a half, there have been significant erosions of the at-will doctrine, although it is still the default status for private employment. With few exceptions, the law that developed to protect employees was not specifically directed to protecting speech. The many state statutes that are concerned with speech and expression tend to be narrowly focused on partisan political activity, such as voting. Nevertheless, there is actual or potential protection for free speech in these statutes and in the many exceptions to at-will employment, including, as I said, contract, statute, and common law. I'll touch briefly on each of these. As we will see, all of these exceptions to the at-will doctrine, protection for the employee is never bulletproof and can be lost where the hot speech crosses a line, and that line usually involves disloyalty to the employer or disruption of the workplace. And of course, all of those are elastic. The first exception to at-will employment I want to mention is contracts, the many kinds of employment agreements that protect employees from at-will discharge. In the lawyer context, the most important contract is probably the partnership agreement. For lawyers represented by a union, there's a collective bargaining agreement. There aren't a lot of lawyers in private practice protected by unions. I must say my law firm is one of them. Lucky us. Beyond that, this exception to at-will is probably most significant for employment lawyers. While employment agreements, including partnership agreements, rarely specify a right to free speech on the part of the employee, many of them, and most collective bargaining agreements, include a provision that limits the right of the employer to terminate or discipline the employee except for cause or for just cause. About 10% of employees, but very few lawyers, are covered by collective bargaining agreements. Depending upon how a cause provision is interpreted or applied, the employee covered by one might have some speech protection. An employment contract's cause protection would likely be interpreted to cover illegal discrimination. even if the contract doesn't say so. And so anti-discrimination analysis, which I will get to, would likely be relevant in determining cause in all kinds of employment contracts. Anti-discrimination law, the second exception. There's a plethora of anti-discrimination law. In New York, that includes laws at the federal level, as well as state and city, as well as bar association rules, and possibly others, depending upon place and issue. And I would like to point out that the former head of the City Human Rights Commission is with us today, Carmelyn Malalas. What these laws do not do specifically, and are not designed to do, is to protect speech rights per se. Speech protection exists as a matter of interpretation, and generally where its protection will serve the goal of anti-discrimination. This is an important distinction to keep in mind, because it tells us that the First Amendment analysis is perhaps of limited relevance. The employer is, in a sense, the referee among competing interests, the initial referee at least, including its own. It may cast itself in liability if it gets it wrong, by illegally permitting speech or illegally forbidding it. I'll speak about the basics of employment discrimination law, but first I want to lay out some of the considerations that have presented such challenges to applying ordinary discrimination law in this post-October 7th moment. The first challenge, as I have said, is that anti-discrimination law wasn't created to protect speech specifically. There are also definitional issues that are contentious in this moment and are crucial to applying ordinary law in the current situation. I'll give you a couple of bullet points. Disagreement about what Zionism means is foremost. Is Zionism an ideology only, a political choice, and thus not entitled to protection against under Title VII? Or is Zionism inherent in being Jewish, such that Zionist means Jew and anti-Zionism means anti-Jewish? Next, discrimination on the basis of ideological difference is not in and of itself outlawed under Title VII. Title VII does not, for example, forbid rejecting an applicant because they are Republican. But what does Title VII say about rejecting or favoring an employee or applicant because they are Zionist or anti-Zionist? Next, when does a political identity also constitute protected class identity? Next, when is a political act also an expression of racial, religious, or other protected identity? The EEOC, the federal agency that administers Title VII, has issued a fact sheet, which I think you have in your materials, in an attempt to address some of the contentious issues present in the workplace in the wake of October 7th. It was issued after October 7th, but I can't tell you exactly when. We tried to find it, and I couldn't find it. If any of you know, I'd like to have the answer to that. And I also believe it's the first anti-discrimination agency that attempted to lay out some of its own thinking post-October 7th. I think it might be useful to look at this to show the basic approach to anti-discrimination law of one agency, and also to show some of the novel choices that the EEOC has made. You'll see under disparate treatment, the first bullet, and I would say that seems straightforward, except, as you will see, it states that Israeli is a national origin group, and some of you may be aware that Israel itself does not agree with that. Israel itself has said Israeli is not a nationality. Long story, some of you probably know it. The second and third bullets address racial stereotyping and discrimination due to marriage and other association, and are also relatively straightforward. The fourth bullet is somewhat novel, and in my opinion, seems to conflate ideology with identity. There's a concept in anti-discrimination law that tries to get at traits that are closely associated with protected identity. And there's a lot of law on traits that are immutable and traits that are voluntary, or what some courts call performative. And courts tend to protect traits that are closely associated and are immutable, closely associated with protected categories and are immutable, less protection for traits that are what is sometimes called performative. Just a quick example, it's not an October 7th example. There was a case a number of years ago of an employment agency that refused to refer for employment anybody with tightly braided hair. People with tightly braided hair are more likely than not to be African American. Nevertheless, the court found that this trait was not immutable, it was performative, and it was not given protection. So that distinction between immutable and performative is important to courts. I think the EEOC is taking a different position. But let me also remind you, if you don't know, that the EEOC's interpretations are not given deference by the Supreme Court or any other court. So that's also important. The fifth bullet, oh, well, let me finish the fourth bullet. I say it's novel and seems to conflate ideology with identity. Query, does it conflate organizational membership politics with protected status? Does it indicate that discrimination against a person who belongs to a civic organization, like, say, Proud Boys, might be illegal because Proud Boys is closely aligned with a particular racial group? In the case of Proud Boys, that might be white people. The fifth bullet, the only one explicitly addressed to speech, raises issues regarding the meaning of, quote, similar speech or conduct. What does similar speech or conduct mean? Similarly bigoted, similarly ignorant, similarly factual, or similarly filled with lies? This attempt to deal with speech directly seems to me is very difficult to apply to any hypo, because it seems to me generally a particular piece of speech is going to be part of a pattern. It's going to be rare that a particular piece of speech will be the element of discrimination, and I think we'll see that in our hypo. Under harassment, the fact sheet might conflict with the principle that employees get to do what they want on their own time. You'll see that it talks about social media postings and how they might affect the workplace. So we should keep in mind that there are some laws that protect employees being able to do whatever they want in their off time. And I'll say a few words later about New York's Labor Law 206, which does exactly that, protects employees' right to engage in what is termed recreational activity in their non-paid, non-work time, and to not be discriminated against or adversely affected in their employment. There are claims, a lot of them, but as far as I know, no decided cases, and if you have any, I'm glad to know about them, regarding speech in the workplace revolving around October 7th and its aftermath. Okay, the next exception is the National Labor Relations Act and collective action. After anti-discrimination law, the most potent exception to at-will is the NLRA. If an associate thinks they've been discriminated against and they talk about it with others, and then that group goes to HR, that might trigger the protection against retaliating against employees for collective activity. The NLRA forbids employer retaliation against employees who engage in collective action for, quote, mutual aid or protection. Mutual aid might be construed, and has been construed, as protection for certain political action or speech. There are analogous cases under the NLRA in which employees claim rights to political expression as a matter of their protected racial status. A case that occurred a few years ago, at Trader Joe's that resulted in both an anti-discrimination claim and also an NLRA claim. The Trader Joe employees wore BLM badges, and Trader Joe's rules forbade wearing political badges. the workers said that this was inextricably involved with their racial identity because they were all black. They lost the discrimination case. As far as I could tell, they settled the NLRA case. Doesn't sound good for making the claim, but I must tell you, I've made this claim a few times under the NLRA. I didn't go as far as filing an unfair labor practice charge, but it can be a very potent claim if you're an employment lawyer, I will tell you that. There's a young partner in my firm who tells me that the places I've made the claim have been bad claims, but they worked. Another exception is common law. There's a lot of common law that might ameliorate the at-will doctrine and afford speech protection. These include public policy exceptions, implied contract and other quasi-contract doctrine, and here there might be employer speech that employees rely upon as some kind of a promise, some kind of quasi-contract promise in employee handbooks or in other public statements. It's weak protection, but it may be some lever for employees. For all of these, there's not much of an enforcement mechanism. The enforcement mechanism is weak at best, so they don't exactly provide reliable protection, or a serious risk for employers. The last thing I'll mention is state laws. I kind of referred to these earlier. There are a lot of state laws that protect employees in various circumstances. A lot focus on partisan political activity, on voting, on things that are very closely partisan. There's one state, I think it's Montana, I can't remember for sure, that has reversed at will entirely, and every employee is protected by some kind of a just cause protection. In New York, as I mentioned, Labor Law 201, I think I said 206, but I think it's 201, provides against, protects employees against discrimination for their recreational activity, which means lawful leisure time activity for which the employee receives no compensation, generally engaged in for recreational purposes. The cases under this law point in, of course, two different directions. In one case, participating in a political vigil was deemed recreational activity, and the employee got protection. In another one, the employee was picketing as a political protest, and the court said that that was not protected. So you have to do your research. So in conclusion, protection for free speech rights for private employees is obviously quite a colorful patchwork quilt. Conduct that's protected for one employee is not protected for another, depending upon the vagaries of the state you live in, the power of publicity, not inconsequential, and other matters that could seem random to the worker. Several law review articles that I found in preparation for my presentation today recommend a national law protecting the free speech right of workers with reasonable defenses for employers. A national law, Congress, right. It seems like the most impossible goal imaginable. But if you think that's impossible, let me show you a map of the Middle East. Thank you.
Thank you, Kathleen, who's now going to join our panel. So Marcy and I are really excited about the panel we've assembled to help us think through best practices and strategies for dealing with hot speech in our workplaces. And I'll introduce them as they come up. So if you're on this panel, I think you know who you are. I'll start by introducing Catherine Christian, who's a partner at Liston Abramson, which she joined after more than 30 years in the Manhattan DA's office, where she had extensive, of course, extensive and supervisory experience. Also notable, she was the first African-American, the youngest person, and the second woman inducted as the president of the New York County Lawyers Association. If she looks familiar to you, that may be because you recognized her from her work as a news analyst for MSNBC and NBC. Next, we have Nakia Gray. Nakaya is the executive director of the National Association for Law Placement, affectionately known by NALP, as everyone who works at a firm and has ever hired a law student or was a law student and never tried to work at a big firm knows. It's the organization that develops the practices that govern the recruiting of lawyers to big firms and that develops the reports that map employment across our profession. Before joining NALP, Nakaya was the managing partner of the DC office of Quarles and Brady, as well as the firm's director of recruiting. Our moderator for the panel today is Susan Coleman, who you've already heard from, who's the current president of the association and is a partner in Jenner and Block's New York office. We are also joined by Brittany McDonald, who is the director and senior counsel for the labor and employment at Diageo. Is that how you say it? Okay, Diageo. I thought it wouldn't be quite as bad as mispronouncing somebody's name, but still it wouldn't be good. I said Diego. Okay. She's also the current co-chair of this Bar Association's Diversity, Equity, and Inclusion Committee. And last but not least is Brad Karp, who is the chair of Paul Weiss and was my little buddy when he was a summer associate many years ago. He's one of the country's leading litigators and corporate advisors, and on the very short list of lawyers everyone recommends to navigate the treacherous states of bet the company litigations. Finally, I would like to remind you to jot down your questions for the panel on the index cards. And I want to thank especially Lisa Freed Groden, Antonio Kouloussis, and Kathleen Peratis for their work on our hypo, significant amount of time, many hours of conversation. And a special shout out to David Kiko for his assistance in helping us develop and uncover the ethical issues that arise in this area. Looking forward to hearing the panel work through these hard issues.
Great. Thank you so much, Mary Lou, also for all of your work on gathering this very esteemed panel and also on the hypo. So much like Dean Diller did, I just want to start with a couple of guidelines, ground rules. As we heard this morning, passions run high about what we are going to talk about, but we are not talking about the substance. What this conversation is really about is how to talk about the issues and setting a framework, how to navigate the issues and what's involved with them. And happily, this panel really represents a lot of different parts of the legal profession, all of whom are facing these issues. We are going to walk through the hypo. It is that. It's a hypothetical, Fred-friendly or not, as we discussed this morning. And so while it will echo many of the things that have happened, it is simply a hypothetical. And we're not here to really judge any particular actions. None of the conversation here is about specifically actions that have been taken. So with that, I'm going to dive right into the hypo, and I hope you'll keep in mind the framework that Kathleen just gave us, which is super helpful. Okay, so Smith & Doe, which I'm going to refer to as SSD, is a 100-lawyer firm with headquarters in New York. And in the days after October 7th, SSD posted a statement on its website. That statement read, "SSD is proud to stand alongside the leaders of peer firms to denounce hatred and attacks on the Jewish community in the United States and abroad, including anti-Semitic activity on U.S. law school campuses following the terrorist attacks on Israel on October 7th, 2023. Some attorneys at SSD are Jewish and have family members or friends living in Israel. Some attorneys at SSD are Arabs and Muslims and have family and friends in Gaza." So to just kick it off, what kinds of considerations go into deciding whether a law firm should speak at all as a firm on world events? Who should be consulted, if anyone? And is there a justification for not speaking? And as I'm talking, I see my friend Brad reach for the microphone. Do you want to kick it off?
I'm happy to kick it off. So as you heard, I've been at Paul Weiss for 40 plus years. I was a summer associate in 1983, shared an office with Elliot Spitzer and Caroline Kennedy. I came to Paul Weiss because it had a very long, vibrant pro bono public interest, progressive liberal democratic history. And we've always taken a lead in addressing hard social justice, racial justice issues. From my first day at the firm, when Ted Sorensen gave an indoctrination speech to all of us. So I've been chair of the firm for 16 years. And part of my mission as chair was to restore the firm's historic advocacy on issues of social justice, racial justice, no matter how provocative, no matter how controversial, and to speak out when I thought expression and communication and messaging really mattered and could make a difference. In the hypothetical, one of the things you heard Susan mention about the SSD firm is that the leader said he or she was proud to join the ranks of those law firms that have spoken out on this issue. What happened at Paul Weiss is on the morning of October 7th, you turn on the news, you see what's going on, you see a terrorist attack, and the way our firm operates is there's a lot of authority vested in me to use my judgment. And I went to my computer and I typed out a message to the Paul Weiss community immediately, denouncing terrorist attacks, standing with the state of Israel, standing with the people of Israel, denouncing the atrocities that had taken place, and hit send. And it went to the 1,100 lawyers and 1,500 non-lawyers at the firm right away. And that's the pattern that we've developed over time. We tend to over-index on speaking out. I recognize that. We will speak out on almost anything and everything. We will speak out early and forcefully, and we give a lot of other law firms cover. Because if we'll do it, they can stand behind what we've said. The world has become increasingly politicized and toxic over the last 7 years. And issues that used to be relatively straightforward or less controversial now are imbued with tremendous political overtones. And I'm getting a lot more flack for taking positions, and it's causing me concern because my ultimate fiduciary duty is to every employee at Paul Weiss, and I don't want to take any actions that will jeopardize the reputation or standing or stature of the firm, and certainly put any employees in difficult positions. And I certainly don't want to antagonize or alienate clients, but I'm willing to antagonize and alienate clients in the cause of justice. So we have a very unique way of approaching these issues. And as long as I'm chair, I'm going to continue down that path and take whatever repercussions may arise.
Sorry, I'm going to turn it over to you in a minute, Kathleen, but one of the things that we heard the deans say this morning was, you have to think about how often you speak and when you don't speak. And I think it was Dean Morrison who said, he thinks it's better sometimes not to speak because if he speaks, it chills other people from speaking. And he also said, looking back on his deanship, I think he said he spoke something like 7 times, but that doesn't speak to the 250 times he didn't speak. So just keeping in mind what you've just said, is there a justification for not speaking? You want to speak to that?
I think there is a lot of justification for not speaking. I think that my firm does only employment law, so what I'm saying is in that context. I think that at the time of the George Floyd murder, everybody wanted to speak out. And since then, we've gotten the idea that everybody should speak out about everything, and everybody shouldn't, in my opinion, and in my firm's opinion. Paul Weiss has a much broader brief than Outen and Golden does, but we've decided, after having made comments on every public issue, and every squash team at every college feels that they have to make a statement these days about everything, we've determined that we're going to talk about things where we have value added, where it's something that is within our expertise, and a lot of things aren't. So I think that there's a value to saying, if I've got value added, if I can really contribute to this conversation, and not just be me too, but really have value added, then we'll speak out, and not otherwise. So that's how we've called it.
Did you want to?
Yeah, thank you. So I'm in the association space, right, which is a little different. NALP is an association of all of the 200 ABA accredited law schools, as well as many major employers throughout the US and Canada. And we have over 3,500 members, right? And so as an association, we are mission driven. And so our members expect that we will be making public statements on issues that are of great importance to them. And so we face these issues every day, but I think employers are going to more frequently face this because it's now becoming an employee retention and recruiting issue, particularly for young talent. They are expecting that their employers are going to speak on issues that are important to them, and they're willing to, they're very much value driven. This is Gen Z, right? They're very value driven, and they want to work for employers that align with their values, and they're willing to take a pay cut to get that. So this is becoming more and more of an issue that folks are going to face. And I'll tell you, we host a legal recruiting summit every year here in New York at one of the law schools. And last year we hosted a panel of law students from all over the law schools here in New York to speak and talk about what they were looking for when they were looking for employment. And a number of the ladies on the panel said that part of the factor that went into their decision of where they were going to apply for a job and what job they were going to accept was how quickly the law firm had been able to get out their statement in response to the Supreme Court's Dobbs decision. Right? Think about that. We can all debate whether that's a good way to be making employment decisions or not.
It's a good way.
But it's what they're doing, right? And so more and more organizations are going to face this issue. Now, in the association space, it's a best practice to have a policy to guide you on thinking through when you're going to make public statements. It's not a policy that says you must make a public statement or what position you're going to take on a public issue, but a policy that says what should be the nexus to your business, what's going to be the decision process used, who's making that decision, so that it's always done consistently and deliberately, because the last thing you want to do is be doing this on an ad hoc basis, because that's the way you're going to get yourself into trouble.
Okay, I'm going to keep going a little bit with the hypothetical so we can tease out some additional issues. So a week after October 7th, a prominent law firm drafted a letter to the deans of some of the top law schools. As we heard this morning, the deans really appreciated that letter, expressing solidarity with Israel and its existential battle with Hamas. SSD was asked to sign on to the letter. So, and this is completely different from the statement now. We're talking about a letter to the deans. What are the considerations about signing on to a letter like this? Who's the intended audience of the letter? What are the goals of the letter? Does anybody want to take that? Go ahead.
Sorry. As one of the people who co-drafted the letter with Joe Schenker of Sullivan and Cromwell, we were starting to see waves of anti-Semitism experienced at major law schools. And Joe and I thought that the response of the law school leadership was tepid at best or worse. And we thought it would be helpful to make a statement indicating that we are the employers of your students and graduates, and we certainly don't want you to produce students that view hate of any kind directed towards any party based on ethnicity, gender, race, etc., to be acceptable and not to be condemned and denounced publicly and forcefully. So we thought it would be helpful, and actually we thought we would give them a little bit of cover, to call for them to address these issues. And we understood it would be somewhat provocative. We thought it had to be done, and we thought it would actually help the law firms to make a statement like that. We tried to solicit broad approval of the letter, and anytime, this is something I've experienced, I'm sure everyone has experienced this, anytime you try to draft something for consideration by a large group, it gets watered down, and you have to make the decision whether it's better to have a forceful statement that is signed onto by a relatively small number of organizations, or a watered down, diluted statement that is signed onto much more broadly. And we decided to try not to water it down and to have whoever was willing to sign it, sign it.
Catherine, did you?
And, you know, I'm a panelist, but I'm also going to ask a question. When I first read the letter, and I was supportive of it, and I'm someone who young attorneys often call me for advice, and I thought one of the goals of the letter, and was also a statement to those law students, we're not going to hire you if we find out, like if you put up on your Instagram or whatever social media, something that's clearly, and obviously people have different opinion what is and what isn't, you know, clearly racist or clearly anti-Semitic. And what I often tell students, college and law students are, and I'm someone in college who worked at an organization called the National Coalition Against Censorship. So in my head, I'm like a First Amendment absolutist. But as a practical person, of course I'm not gonna put what I really feel up and post it for people to see. I'm not a moron. And that's exactly what I tell, you know, people who ask me for advice. So that's what I took from the letter. One, obviously you really believed it was horrible what was happening, but it's also a statement, and by the way, law students, don't even bother applying to my law firm if you engage in this activity.
So let me keep going with the hypothetical, because I think we're gonna, oh, yeah. I think we're gonna tease out a few more issues somewhat along those lines. So SSD decides to sign the letter, and Fatima Musa is a fifth-year associate at the firm. She's of Palestinian descent who has relatives in Gaza. The partners were so impressed with her performance, they assigned her to work on the Teva Pharma account, a multinational pharmaceutical firm with headquarters in Israel. It provides a substantial revenue stream to SSD. Ms. Musa, who was a member of Students for Justice in Palestine when she was in law school, has no objections to representing Israeli clients, and she has very respectful work relationships with her Jewish colleagues at the firm, and counts among her personal friends many Jewish and Palestinian peace activists in Israel and abroad. Her work on the Teva Pharma legal matters accounts for nearly 50% of her assignments. Additionally, it provides her the opportunity to work with a young equity partner at the firm and one of its top litigators, Joel Steen, who is Jewish and a grandchild of a Holocaust survivor. Ms. Musa and Mr. Steen have a close professional relationship, and they avoid discussing the Palestinian-Israeli conflict, aware that they probably have very different views. In the days after October 7th, Ms. Musa noticed a change in Mr. Steen's attitude toward her. He was more businesslike, less friendly, and while he was on the phone with a Teva Pharma official based in Israel, she overheard him make a remark that she regarded as Islamophobic. Ms. Musa discussed the situation with 2 other Muslim colleagues at the firm, one of them a lawyer, and they agreed with her assessment of Mr. Steen's remarks. The following day, reluctant to confront Mr. Steen, Ms. Musa reported Mr. Steen's comments to HR, and she asked HR to ask Mr. Steen to temper his comments in the workplace. So, first of all, should a firm's anti-discrimination policy explicitly mention anti-Semitism and Islamophobia? Let's start with that. But you want to take that?
I think specifically mentioning them rather than just talking about discrimination maybe raises more difficulties than it solves, because if you raise them, you might have to define them, and defining them might take you the rest of your natural life, because that's not going to go down so easily in the firm unless the managing partner decides what it's going to be, and that's that. An interesting thing that this hypo that we left out on purpose, actually, is she complained about what she heard him say or thought she heard him say, but she didn't mention that his demeanor became chilly. And if his demeanor became chilly before she had said or done anything, that does sound like he was stereotyping her and just assuming that because she was Palestinian that she had views that were unacceptable. Islamophobia tends to be different in a lot of ways from anti-Semitism. But one of the things Islamophobia tends to be, the stereotyping tends to be, you think that they're terrorists. That's the heart of fear and discrimination against Arabs in general and Palestinians in particular. And sounds like he was doing that, and that's a problem.
So, and Brittany, let me turn to you. Should the firm's DEI officer be part of any discussions or decisions to talk to Mr. Steen?
Well, the quick answer to that is absolutely. And, you know, when you think about DEI officers, they should be included as a part of, when we talked about, I think you asked earlier on, who should be consulted when your company, for instance, for me in the private sector, when you're discussing coming out with, you know, bold political statements on social justice or signing on to particular letters and so forth, who are those key stakeholders that you should be engaging? Absolutely, you should be engaging your DEI officers, you should be engaging your executive committees. You should also be engaging the employees, right? Those who these particular issues might directly be impacting, right? So as in the private sector, we should be engaging with our ERG groups, having conversations, having discussions before any decision is made, because any decision made, it needs to be very thoughtful, it needs to be informed, and you need to ensure that you're really engaging all of those key stakeholders.
And I think, Catherine, when we were speaking about this before the panel, I think, and I know previously you worked at the DA's office, what would their reaction be?
And I'm not the employment lawyer, but I agree. The problem, when I was in the DA's office when the George Floyd happened, and the DA Vance at the time issued a very strong anti-racist, anti-systemic racism statement, which was great. But what happened, and when you become senior, you get the phone calls, it was clear it was meant toward anti-Black racism. So you may have remembered during the COVID lockdown in New York City what was happening. Asians were being assaulted and were victims of horrible things. So it was, well, what about us? So that's what happens when you issue a statement just for one, because then it's like, well, what about my group? And it wasn't deliberate, it was just but you have to consider that. And I think that's the problem when you also define and, you know, one group, because then the next week or day, it's going to be another group who's viciously attacked.
And this may be an impossible question. So what, if anything, should the firm say to Mr. Steen, and what, if anything, should the firm say to Ms. Musa, and should her assignments be changed in any way? take that?
Yeah, dare I say, because this is, I wouldn't have a job. And I think, as an employment attorney, you first need to investigate, right? So you can't just take her statement for what it is. You need to ensure that there is a thorough investigation, that everyone's given a fair opportunity to respond. There's some due process, right, that's involved here before any action, if any, is taken with respect to either Ms. Musa or Mr. Steen. And then you proceed from there. But there does need to be at least some sort of investigation involved.
Yeah, I would say as an employment lawyer, as a practical matter, Ms. Musa is now cooked. Nobody likes to be accused of discrimination. And if you accuse somebody of discrimination, you're taking a big risk. If she consulted me at this point and said, should I complain, I would say, figure out what you want to do about a career in the firm. And if you want to stay, you should probably suck it up, because this is going to do you no good. If you're prepared to consider leaving, go ahead and complain. But that is a reality, and as an employment lawyer, you have to present that to the person who's considering complaining. Now, maybe there are places where she would be absolutely fine, and the person she's complaining about would just let it go, but it is something that you have to think about before you take that step.
Can I just respond really quickly? And I think that's a fair point. I would just add, though, as an in-house employment attorney, that we do encourage our employees to speak up. And I totally get that, like, what are the inevitable consequences? But we want to hear those claims. We want to hear those things so that we can at least diligently and do everything that we can in-house to ensure that, we're at least listening to all employees and addressing any concerns that there may be.
Okay, let's move on, tease out another point with respect to the hypothetical. Now we're in November, and as the conflict in Gaza continues, Ms. Musa contacted the firm's leadership to request a public statement from the firm parallel to the one it had issued early on, tracking its support for Israel, but adding its support for the safety of the Palestinian people. The firm refused. She contacted HR to amend her internal complaint alleging Islamophobia. So how should the firm have decided how to respond to the request for a statement? And what, if any, kind of exposure does the firm have? Do you want to?
I'm happy to do the former part. God knows what the exposure is. I just play a lawyer. I view it, as the leader of the firm, I view it as my job to make sure I have as good an understanding as I can have of the vibe and the pulse of the firm. So when there is a major event that takes place, I will try to immediately call for a town hall of the entire firm, and we have a sufficiently casual and informal environment that I will encourage people to speak up, ask the questions, either in writing if they're anxious or orally during the town hall, to try to have a dialogue and a conversation about difficult and uncomfortable topics. I've always found that it's much better to get everything out so you feel like you're part of one institution trying to work through a sensitive problem than having things metastasize internally and have things become a powder keg and ultimately explode. So after October 7th, I called for a town hall. At that point, a couple of weeks had gone by and the Israeli campaign against Gaza had intensified. So you were starting to have the situation where the safety of civilians in Gaza was a real issue. And during the town hall, there were lots of discussions around both sides of the issue. And some of the Muslim members of my law firm said we should issue a statement calling for a ceasefire. And I said, I view that as an overtly political statement at that time, and we don't do that. We certainly would call for peace and safety and humanitarian relief and aid to all those affected by the crisis. I took the opportunity to denounce hatred broadly, not just anti-Semitism, which had been the immediate focus in the aftermath of October 7th, because you want to be an institution, I think everyone prides themselves on being an institution that will not tolerate hate of any kind. So we issued that statement in the wake of that town hall in consultation with Palestinians and other Muslim members of our community, and it really did calm emotions within the firm.
Kathleen, you want to speak to the legal implications?
Well, yeah, I think that one person's non-political statement might be somebody else's political statement. Calling for peace and lack of hatred, I would, in my firm when we had this discussion, it's sort of the equivalent of not saying Black Lives Matter, but all lives matter, which is not really addressing the point or the issue according to some. So every statement you make, however parv, however neutral you think it is actually political, because you're reflecting on a very important political situation. So getting to the legal issue, the firm made a statement that was pro-Israel. The Palestinians wanted some balance. I think the firm is not required to speak, obviously, you can't say that, but I think every little data point can be used in a subsequent claim that there was a hostile work environment created. So not any one thing is enough, but a lot of little things can be enough, and I think that's the risk.
Okay, let's move on and get a little more into the hypo. In November and December, Ms. Musa and Mr. Steen each posted graphic photographs of the conflict to their personal social media accounts. SSD associates began to circulate petitions alleging that Ms. Musa's postings were offensive and violated the firm's anti-harassment policy and its policy against anti-Semitism. One associate, whose family member was taken as a hostage, specifically asked not to be assigned to work with Ms. Musa on any matter going forward. So what should the firm do or say to Ms. Musa and Mr. Steen about their postings, and is the firm entitled to differentiate between the two based on their positions in the firm? Anybody want to start? Brad, you want
to? We have a no social media policy other than professional work matters, because if you don't, you really get into areas that can become very complicated very quickly. And we try to regulate the use of social media in a responsible way, and it gets violated reasonably frequently, and we're very vigilant about clamping down on that. We are completely judgment neutral. You can't post something on one side of an issue that has nothing to do with Paul Weiss, and it's okay, and another side of an issue it's not okay. You just cannot do it. And no one has complained to us about that policy, and it makes my life, our lives, a little bit easier to deal with. Just easier.
And maybe Brittany, just from an in-house perspective?
It's just a little bit different in the sense that we do advise our employees that to the extent that you're representing any of our, and Diageo has a long list of brands, but if you are representing any of those brands or representing yourself or holding yourself out to be an employee of Diageo, that you be thoughtful about what you post, and that you just think twice before you post anything, because we do very publicly say that we may at any one point in time monitor those social media accounts. And so, I agree though on the other side of it is that we can't look at any and every social media post that there is out there, but we do try to put that caveat out there to at least, have our employees at least, think before they do post something.
And I know you don't speak for all Gen Xers, but what do you think the reaction is?
I think that's a very wise policy to have. I think it needs to be explained to them, right? They're coming from a world where they've grown up with this technology. They're used to using it every day, speaking publicly every day on every thought that goes through their head and everything they eat. And so that's the environment they're coming from. So I think those are great policies. Just need to explain it to them so they understand.
Did you want to?
Just wanted to point out that it might be a violation of New York State's labor law that prohibits disadvantaging an employee because of something that they did in their, quote, recreational activity life. I'm not sure, I don't know if there's been any attempt to enforce anti-social media policies among law firms or anybody else, but there's certainly a good argument that it violates state law, so.
Okay, let's keep going.
Why? I violated 2 laws so far.
In January and February, matters relating to the conflict have ratcheted up, and Ms. Musa attended several peaceful public protests. She was filmed at one holding up a Stop the Genocide sign and chanting "From the river to the sea, Palestine will be free." The video was posted on several sites, and SSD's website was inundated with messages demanding her employment termination, pointing to the hypocrisy of the firm's denouncement of anti-Semitism while employing an avowed anti-Semite who was advocating for the genocide of the Jews. Mr. Steen insisted that Ms. Musa be removed from all Teva Pharma assignments and refused to continue to work with her, and tells her that he is personally offended by her acts and comments, and he and probably others at the firm won't continue to work with her. The client, Teva, has contacted SSD partners and demanded that the firm terminate Ms. Musa or else risk losing the account. And Ms. Musa has told SSD that if she's fired or removed, she'll file a grievance against the firm. Mr. Steen, under RPC 8.4G. So I guess in the first instance, maybe to start with, you know, how should the firm respond to the website messages? Or maybe just taking it for a moment, let's just step back from the hypothetical and talk about how, just as a general matter, clients fit into all of this. Do you want to start with that?
Should consult my counsel first. Look, law firms have one source of revenue, and that source of revenue are its clients. So we cannot not take into account client reactions to any one of a number of issues. So clients play a very significant role in the decisions that we make, because we have lawyers and we have clients, and that's our entire business model. And if you're going to drive away your clients, you're not going to have lawyers for much longer. So yes, clients are important. We will not do something that we think is inappropriate at the behest of a client, ever. So, you know, we've taken a lot of positions that antagonized a number of clients, and we thought we would always explain our position to the client before we took the position, if it was going to be on something that was non-legal in nature. And we've always had good conversations. So yes, the client reactions matter a lot. And now I'm going to turn it over to my lawyer to tell me what we should do and how we should handle this.
Yeah, you definitely should have gotten advice of counsel before you said all that. It is clearly illegal to change somebody's assignment because the client wanted to, if what the client is asking for is illegal in itself. So we then have to ask whether what was happening to her, and now there's a lot going on, but whether it's illegal in the sense that it was happening because it's either anti-Muslim or anti-Palestinian. And if it was, whether the client complains or not, you can't remove her. But I actually have to say that before all of these bad things started happening around her, she's probably not got a viable position in the firm already. Part of this is a client that I had a couple of months ago, and that's why a little bit of it found its way into the hypothetical. She was at a rally holding a sign saying, "Stop the genocide." And Stop the Genocide alone was, in December, regarded as being anti-Semitic. And her position at her firm, very successful, high-level partner, became untenable. And she could have fought it, but if she had, she would have been screwed on her comp for the next 10 years. So those practicalities really, really matter. And it didn't take much, and doesn't today take much to be, I mean, Stop the Genocide and From the River to the Sea is regarded as unacceptable in a lot of places. So those are the practicalities.
So just to, again, maybe try to take it out of the context of Israel and Hamas, you know, and we are maybe in a somewhat hostile DEI world. What if a client says, "I want a diverse team on my matter"? Is that okay? How does that work in this environment?
Us constantly, and we provide diverse teams on client matters where the client requests them. I mean, I think that's actually, we try to provide diverse teams on every matter. And look, 3 of my senior partners are Loretta Lynch, Jay Johnson, and Ted Wells. And so diversity is a very major part of who we are. We're about to celebrate the 70th anniversary of Brown versus Board of Education on May 17th. You know, we represented Oliver Brown against the Topeka Board of Education. So diversity is a really big deal. Client wants a diverse team, client gets a diverse team. I think it's a perfectly appropriate request.
And I don't want to put you on the spot, but as a client, you know, what goes into your thinking about when and whether to say this lawyer's okay and that lawyer's not?
Yeah, no, I think it, you know, listen, just to go to your earlier question too, inclusion and diversity is the heart and is at the fabric of what we do. And so we do expect, and I have had conversations with a number of our external law firms, that their teams, you know, reflect the core of and the spirit of what and who we are as a particular company. So we do would like and expect to see diverse teams to be more aligned with the spirit of who we are as Diageo. So I think I may have missed your other question because I was still on the.
Just what circumstances would you say? You know, we
put it another way. What law did I just violate?
Listen, I will say that the conversation became more topical during 2020 when we, you know, were discussing, and a lot of number of companies came out, you know, during the George Floyd murders, and then you saw the Black Lives Matter versus All Lives Matters, and so forth. It was time for the conversation where you saw a number of different companies begin to, you know, make bold statements about inclusion, diversity. And again, inclusion diversity was always at the heart of what Diageo does, but we came back out and sort of, you know, made another statement about inclusion and diversity to sort of, you know, suggest like this is who we are and this is what we, you know, sort of believe in, and this is sort of what we represent as a company. And so we are very much more, you know, looking to our partners to reflect some of those same themes that we as a company reflect as well too.
And what if the messages, you know, to the firm's website in reaction to what was posted include threats of violence against the firm or Ms. Musa? Then what?
I think you call the police.
I was going to say.
Okay, so now, well, one other thing. Is the firm, can the firm just remove Ms. Musa upon Mr. Steen's demand? And maybe we should think about that in more sort of gradations of behavior. At what point can they?
At what point? I don't know whether the point has been reached where the firm would not have a big concern about a meritorious discrimination complaint. You know, he can remove her for any reason or no reason, but not for an illegal reason. And she's got a lot of evidence by now that this reason may not be legal, in my opinion. I mean, I'd take the case.
Okay, so now Mr. Steen, for his part, begins to volunteer his legal services to a new Zionist organization that represents individuals who advocate for pro-Israel causes. He sought to recruit SSD associates to join him, including both Muslims and Jews, and several lawyers in the firm have said he was overly aggressive in seeking to recruit associates to help, and they contact HR to file a complaint requesting not to work with Mr. Steen. So what, if anything, should the firm do with respect to Mr. Steen's volunteer work? Yeah.
I might as well just keep going.
Sure.
At some point, and the point I think was many months ago, leadership of the firm should sit I'm just being pragmatic, I'm sure I'm violating a law again, but I'm just being pragmatic. You should sit down with Mr. Steen and say, you can't continue to do what you're doing. You're creating all sorts of noise. It's really bad for you. It's really bad for the firm. It's hurting your standing in the partnership. It's hurting your standing more broadly in the firm. As a piece of professional and personal advice, tone it down, watch your actions, be careful. You're going to get yourself and us in a lot of trouble. I assume you could do that.
Yeah, no, I agree with
sirens come by.
I agree with that, but I do think he gets to do the pro bono work he wants to do. I think he shouldn't be leaning on associates, and he shouldn't be, you know, doing the other bad-mouthing that maybe he was doing, but he certainly is entitled to engage in that pro bono work, in my opinion. I mean, the firm might have a different view, but from a legal point of view, I don't see any problem with that.
Okay. Now, moving a little bit forward, Leslie Sweetbriar is a white Christian student in her third year at a top-tier law school. Last summer, Ms. Sweetbriar participated in SSD's 2L summer program and received an offer to join the firm as a first-year associate in 2024. And after she accepted the offer, SSD learned that she publicly supported the Republic of South Africa's genocide claims against Israel at the International Court of Justice, and that she had liked Human Rights Watch's report characterizing Israel as a state practicing apartheid. So may SSD rescind the offer based on her political views?
Yes.
So if legally they can do it, I'm going to turn to Nakaya just to sort of talk about the implications of that.
Yeah, so NALP has its principles for a fair and ethical recruitment process, which is our guidelines to the industry on how employers, law schools, and law students should all participate in the recruiting process in a fair and ethical manner. And one of our main principles in that is that employers should honor their commitments. And if they need to rescind the offer or modify the offer in some manner, then they should do so in a way that minimizes the impact to the student. And this situation, this fact situation we have here, illustrates why we have that principle. So Ms. Sweetbriar in the case is a 3L student, so she's in her last year of law school. Now, for those of you who didn't graduate recently or are not involved with law schools, you may not realize, but the recruiting process has moved very, very early into the educational process. Most students now secure their postgraduate employment in that summer between their first and second years of law school, and if not then during their second year. Very, very, very few law firms since the Great Recession will make an offer to a student who's in their third year. Last year, only 148 offers to 3L students were made by law firms in the entire nation. There are over 35,000 graduates in that class, so less than 0.5% of them received an offer in their third year to join a law firm. So now if the firm withdraws Ms. Sweetbrier's offer and rescinds it, now she's in the worst position than if she had never received the offer in the first place, because now it's extremely unlikely she will go into private practice. She may be able to get a job in another industry segment, but that affects her practice, what area of law she practices, affects whether she becomes an attorney at all. So she's very much harmed by that. So under NALP's principles, we would say that the employer has a duty to think through whether there are other things they can do that are less harmful to Ms. Sweetbrier than just rescinding the offer, like talking with her, talking through the issues with her, talking through, could she remove the offending posts, could she unlike the posts that are concerned here, right? I mean, I think the thing that employers need to really think about in this context is you have a student who is one day in an environment where they are encouraged to engage in a very robust, vigorous dialogue on every social issue there may be. You heard the deans talking about that. That's a fundamental part of the law school experience. And they go from that one day to the next day, having accepted the law firm's offer and now being in a place where they have very limited free speech rights or no free speech rights, but yet they're still on campus, right? So it's very, very confusing for them. And if the employer does not make clear to those students, here's my expectations about social media, here's my expectations about public speech, then I think the employer is part of the problem, because they haven't explained that to a student. You can't expect somebody who has very limited experience in the professional environment or no experience in the professional environment to understand that. So it needs to be part of an ongoing dialogue.
Does anybody else want to comment on that?
Yeah, no, I think it's a fair point. And I think, again, from an in-house, just private organizational perspective, that, you know, as I think about that hypo, I think my initial assessment would be, okay, they're not yet employed, and I think it goes to what you're saying, that, okay, they're not yet exposed to our various policies and procedures, our code of business conduct, and so forth. Let's give them the appropriate training. Let's you know, let them know sort of what we expect from our employees, and then at least we put that employee on notice. Now, it's a different story, right? Once we hire the employee and the employee continues to maybe display some type of behavior that's against or directly opposed to sort of our policies, and again, you know, I continue to dive back to our code of business conduct, then maybe we're having a different conversation at that point.
3L was a summer associate at the law firm and got an offer. I mean, we certainly spend a few days going through all of the policies at the beginning of the summer associate program, making sure that every employee of the firm, whether it's a summer associate, a permanent associate, or otherwise, understands the policies, understands that actions have consequences. So if it would be lawful to take an action, I think there'd be plenty of due process in most law firms.
So I want to take a step back from the hypothetical and talk a little bit about, you know, at least to me, it feels like we have spent a lot of time over the last 10 years trying to increase DEI, trying to tell people that they should bring their whole selves to work. We want to know the real you. And in a way, Catherine, this goes to something you talked about earlier. If you were advising someone who was about to start at a law firm, is that advice you would give them? You may need a...
You know, I don't think of, like we say, the real you. To me, I go back to common sense. That means, you know, how your hair is, like I think someone said, you know, be natural, wear, you know, a dress that, you know, is not typical. That to me doesn't mean that if you have some political view, that you can feel that you can express it and not have your firm say, whoa, 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 wait a minute, or post things. And, you know, it was interesting to hear about the social media. Apparently it's illegal, but, you know, I think it's good advice to say to a law student or a young lawyer, you know, you think it's not there forever, it is, even if you take it down, and that will impact you in getting other jobs or how people will view you. And I always think you should just speak truth to people. Yes, I'm a First Amendment absolutist, but yes, you have a right to say, Israel good, Israel bad, but, so there are those realities, and as Brad said about clients, no clients, no firm. So you always have to, I think, speak, the truth to particularly the law students who, okay, this nice warm and fuzzy world where you can protest, that's gonna stop once you go to a government office or a law firm. You're gonna have to sort of keep that in check.
I also think the world has really been transformed in dangerous ways in the last, let's say hypothetically, since January 20th, 2016, where things that everyone took for granted, DEI good, ESG good, have become weaponized. And you're going to see this really accelerate in the lead up to the November election, where everything is now viewed through a red state, blue state, anti-DEI, anti-ESG, pro-DEI, pro-ESG prism. And it's impossible, because we advise clients on this all the time, it's impossible to navigate the terrain because every state has either a Democratic or Republican attorney general. They are taking their cues from the top of the house, and they're going after corporations for being either too pro-ESG, too pro-DEI, or the opposite. And you have the Supreme Court weighing in with the Harvard UNC decision. And all of a sudden, ESG, DEI is a dirty acronym. And it is a complete upheaval of what we all thought were fundamental tenets a decade ago. And you're just watching this terrain become so perilous and treacherous. Trying to navigate it is next to impossible. For civilian lawyers, for in-house lawyers, for clients, public company clients, private company clients, it's a brutal period that we're going through, and it's going to get a lot worse before, if ever, it gets better.
We do actually say that. We do tell, employees, especially once they're, initially onboarded to the company, to bring your full selves. We value diversity. We want diverse opinions and diverse ideas and diverse thoughts brought to the table. But the caveat to that, and what we also do tell our employees, is that we be respectful of others when you are expressing whatever your independent views are. Be considerate of others as well too, because for me, I'm not only the employment attorney for North America. I've done work for the UK, Europe, and our other global markets, and I've realized how big of a company we really are. And it's almost, to your very good point, it's almost remotely impossible to just expect for one thought and opinion to maybe prevail over from the U.S. to prevail over someone who might be living in Ghana or elsewhere. And so I think, but we want you to be yourself. We just want you to just be thoughtful and respectful and considerate when you're, stating, saying, posting on your social medias or anything else.
Just make one joke. That Mary Lou will appreciate. When I was a young associate, I was working for Judge Rifkin, Paul Weiss Rifkin, and he looked at me and he said, "I want you to be yourself, only less so."
Can I just add to that? Yeah, so what we're not, it would be lovely if you could be your authentic self at all times. The fact is that just doesn't work, right? We're talking about you're bringing your professional self, your adapted self to work, and that's the line that we're saying, right? When we look at the numbers of attorneys in law firms in particular, we see a dramatic fall off for diverse and women associates in particular at that conversion point to partner, where we're seeing very, very different rates of conversion if you are diverse or a female versus if you are white and male. And a lot of that has to do with what is expected in the workplace and who you are and who you're showing up to be. So it would be lovely if everybody could be their authentic self. The reality of it is that you need to be your professional self to be successful in the workplace.
Kathleen, were you going to comment?
Not sure I have value added at this point on this question, but I think that sometimes an associate in a law firm is just a perfect fit, and you bring yourself, your whole self, and it works. But sometimes you bring your whole self and it doesn't work, so it depends on how wonderful a fit you are with the culture of the firm.
And just, you know, we've obviously spoken a lot about law firms and in-house. What about government entities? Would we be speaking about anything differently? And what about union shops? Does anybody want to speak to that?
I'm an employment lawyer, not a labor lawyer, although, as I said, I've threatened NLRA claims with some success, but no, it's not my expertise, and certainly not public employees.
I can say in the DA's office, you have, none of the attorneys are unionized, but you have most of the non-attorneys are. And I remember being a supervisor, there are particular rules that unions have, what the do's and the don'ts and the rights that union employees have, whereas the non-union don't have. You're sort of at will. But and it was a large government office, and you have the same issues. Obviously, you don't have the client issue, but you have, you know, colleagues, and as you're very, well, after COVID, they've spaced out people, but you're really on top of each other. And what you say, be professional. You can be yourself, but be respectful. And I think, you know, and I'm not, you know, you have a firm of 1,100, I have a firm of 9 attorneys. I think probably in government offices, they're more in tuned to immediately responding. There, in addition to a DEI officer, there's an EEO officer, and there's a whole process to make an EEO complaint. And so I think, you know, they are just more in tune to dealing with these issues as they come up. And also, because it is public, there really is, so you cannot, there's not a strict guidelines about not having social media, but under no circumstances can you obviously post anything about your work or anything like that. But I do think probably government offices are better at dealing with these issues than probably corporations or law firms. But that's just my own personal experience from being in a large government office for so many years.
One way this is intersected with the private practice is the union representing a number of workers who work at public interest organizations like Legal Aid and Legal Services Corporation passed a resolution this fall that was avowedly anti-Semitic. And one of the issues, you know, we do an enormous amount of pro bono work, and we are enormously supportive of these public interest organizations. And it puts the onus on us, having made various anti-hate statements. You now have organizations that have taken positions that are hateful, avowedly hateful. They passed by a majority of the union members voted in support of these hateful resolutions. What do we do? Because we subsidize a lot of these organizations. We spend well over $1 million in direct financial contributions to these organizations, and we provide tens of thousands of pro bono hours. Do we withdraw? Because that will wind up hurting the individuals these organizations are protecting. Do we provide our compensation and our pro bono work in different ways? So we're debating that right now at the law firm, and it's a really hard issue.
So I'm just some of the questions. I guess we've really sort of answered this. Is the guidance for a law firm associate facing discrimination that they should not complain? I think we've sort of touched on that. But what about non-retaliation policies? Can you speak to that?
Yeah, I mean, what I said when I talked about how I would counsel this woman, retaliation is illegal, and often a retaliation is easier to prove than the underlying discrimination. I've seen many cases where a weak discrimination case has turned into a strong retaliation case. So yeah, retaliation is very serious, and as I said, sometimes easier to prove. But before you even get to that point, I, counsel the person to think through what they want to do and what the ramifications are. But anti-retaliation is taken extraordinarily seriously by all of the agencies.
Can I add something to that?
Sure,
'Cause
sure.
You said that that we came out that the associate here shouldn't complain. I would say that there's also probably other avenues that could be taken and explored to deal with her grievances, or for her to feel like she's been heard and validated, that maybe go a little more sophisticated and don't quite go to a complaint. Like, there's questions, is there another partner in the firm who's a mentor to her, who can maybe talk to this partner, Mr. Stern, on her behalf and kind of mediate and deal with it that way before it goes to a full complaint where there could be some backlash against her. So I think there are other options as well in the firm.
I completely agree. I think it would be a terrible result if the message taken away from this is associates should not complain. We encourage anyone who's been wronged or grieved, we encourage them to come forward. And as you say, there are lots of different ways you can come forward, formally and informally.
Okay, there's another question. The hypo about the 3L, I understand it's legal to terminate her because political beliefs are not a protected class. But liking an ICJ ruling and outcome, how is that a violation of policy? I think that was part of the hypothetical, but maybe that alone wouldn't do it. But
well, so I'm not a labor and employee attorney. I was an IP attorney, so that's way out of my realm to say whether that's legal or not. But as far as what NALP's position would be and what our principals counsel is that, again, you should look at what is the impact going to be to that candidate if you withdraw the offer, and are there other options available to you that have a less severe impact on the candidate, and that's more fair given the circumstance.
I think that this last question gets us back to where we started, which is that most employees are at will. And for most employees who are at will, you can be fired for any reason or no reason. And there are exceptions, but the default is at will, and I think that's where she finds herself legally.
Yeah, although again, from a pragmatic perspective, do you really want to lead an organization that is going to take punitive, draconian measures against a 23-year-old for some liking of a post? I agree with you. It's all a continuum. It's all a spectrum. And if you're way to one end of the spectrum on the wrong side, that's one thing. But if you're in the middle and there are mitigating steps you can take, look for solutions, not problems.
Yeah, and to play off of that and say the students do talk to each other, and it becomes a reputation on the law school campuses for the employers. And so if that offer is withdrawn, the other students are going to know about it, and it's going to become now the lore of the law school that gets passed down for the next 10 years. And that will affect who's applying to those employers. So there's other ramifications I think the employer needs to think through before they just rescind that offer.
So there's a question again about law firms generally speaking out. Maybe it's law firms, companies, everybody does seem to have made a statement. And without getting into, I think the question sort of suggests, how do you pick between topics? You speak out on George Floyd, you don't speak out on what happened in Israel or Palestine. I mean, has any of this, recognizing that Paul Weiss has a long history, for all of us, I mean, and I can speak for myself, I think these statements are fraught, and you worry about what you're leaving out or what happens tomorrow. Should we maybe get back to, why should we speak out every time, I guess is the question.
Maybe not every time, but most every time. Again, it depends on the institution and what the traditions and histories are, the expectations of the lawyers who are joining the institution, the partners who are at the institution. I probably speak out once every 4 months on some issue of moment. And if I don't speak out, my silence will be viewed by a lot of the constituencies within the firm as substantive and conspicuous. So, almost always I'm speaking out on the side, in quotes, of justice, as defined by Paul Weiss.
Does anybody else?
Yeah,
Okay.
so at NALP, we go back to what is the nexus to our business and our mission. And so we were actually asked by a number of members, were we going to make a statement on the Israel-Gaza situation? And ultimately, I decided not to. Now, I've been only the head of the association for the last year and a half, but I looked at the history of when the association spoke and when it didn't, and I felt too strongly on this particular issue that we had not spoken out on the Ukraine, the war in the Ukraine, or some other situations that if I spoke out on this particular issue, my silence or the organization's silence on other issues were going to be, that was going to end up being speaking in a way that we didn't want it to. And so I think there's a lot of considerations you have to, silence speaks just as loudly as when you speak affirmatively on these matters.
So one other question has more to do with pro bono. I guess Mr. Steen's taking on certain pro bono matters. What policies should a firm have to help them decide whether to take a pro bono case that a particular associate or partner wants to take?
I think taking a pro bono case is different from, I think, what Mr. Steen does in the hypo, which is use his private time to engage in pro bono work, which certainly can raise some issues. In my firm, we have a very active pro bono process, and we decide whether somebody's got a righteous claim, whether they would otherwise go unrepresented, whether it fits within our criteria. I think most firms have a robust process to decide whether a particular case is for them. And that's the right way to go, I think.
We have a very broad view about pro bono. I don't think I've ever turned down a pro bono request in 16 years as chair of the firm and 6 years as head of the litigation department before that. It's what we do. Everyone has their own individual causes. I suppose you could come up with a hypothetical where you're doing something, you're representing some odious cause on a pro bono basis. It hasn't come up. I'm sure it'll come up when I get back to the office. And I'll call you.
The more odious, the more strong the claim would be to take it, if you're a free speech absolutist.
Okay. Well, I don't know if anybody wants to make any closing remarks, but this has been a wonderful conversation. And Kathleen.
Mary Lou's not here.
Yeah,
there she is. But you all don't know how much work this person put into this, yes, and how fabulous she's been, squaring the circles and toning down stuff. She's just been great. So I really want to thank Mary Lou. Yeah.
And Marcy. And I want to thank our panel. I want to thank again the Bar Association, particularly Susan, for her leadership in pushing us to deal with these hard topics, and then the staff, especially, and I'll leave people out, but I know Martha, Eric, Cameron, and Laura, who fed us a wonderful lunch. I want to thank our panel for their time and their wisdom, and all of you for taking the time and the initiative to sit with us without any CLE credit in this controversy, and to think through with us, even though there's passion and pain in these issues. I know we haven't unlocked the secret answer, and we can't send you home with a formula for dealing with these issues. We hope we have left you with a sense that context does matter, and that careful communication and patient translation are critical elements of our work. And most of all, that it is work. And it is in part work that we as lawyers are specially trained to do. It's an area that demands our attention as lawyers and as people. It's worth the struggle. I leave you with the words of the Persian poet Rumi, who said, "Out beyond ideas of wrongdoing and right doing, there is a field. I will meet you there." Thank you.
And I'm just going to take the president's prerogative to say thank you again to Mary Lou and to Marcy. And I will say one other thing, which is, this morning, I think one of the deans said that the one place in the whole world where these kinds of ideas and challenging topics can be addressed is in the university. Well, no, that turns out not to be true. It can be done at the Bar Association, and we hope to see you again soon. So thanks very much.